Hello, and welcome to episode 19 of The Legal Scoop, one of our webinar series here at LOMAD, where we talk about recent notable wins that either our attorneys or our staff had. I'm Brendan Shannon. I'm an associate attorney with the Law Office of Melissa Day, and I'm here to talk about one of my own wins. That's the benefit of having your own show, is that you get to toot your own horn sometimes. The reason I wanted to talk about one of my wins is because it touches on an issue that I'm sure we've talked about on this show before, that I know you've seen in our newsletter if you subscribe to our newsletter, and if you don't, you should. And that I would be willing to bet, although I don't remember offhand, that Melanie Daly's discussed in her show webinar series, The Daily Grind. And that is the issue of the Patalan case. Now, this relates to occupational disease claims, which, as you all know, watching at home, is a very common issue in comp. Basically a case where someone's claiming that they injured themselves due to repetitive use of an extremity or their back or anything like that. And the reason I bring that up is because I had a recent win involving the Patalan decision. The Patalan decision states that basically a doctor issuing an opinion on causal relationship in a repetitive use or an occupational disease type claim must demonstrate a really sufficient knowledge of the claimant's job duties, and that gets pretty detailed. They have to be able to discuss, like the specific things that the claimant did throughout the day, for how long, any weights that are associated with what they were doing, and then link those activities to the injury being claimed. Now, a lot of doctors don't do this, but the reason this case that I had is so interesting is that this doctor tried to do it, but fell short. So basic facts of this case: it's controverted claim for repetitive use carpal tunnel, bilateral carpal tunnel. And the claimant stated that he had been a groundskeeper for over a decade, 12 years, I believe was the exact number. And that ultimately that led to him developing carpal tunnel. Now, the treating doctor went through the things that the claimant allegedly did throughout the day in detail, with hours spent, at least some general reference to the amount of weight that was lifted or moved on any given day, and found causal relationship for bilateral carpal tunnel. Now, a lot of people would say, well, that satisfies Patalan, your case is sunk. We took testimony, and basically, through the claimant's testimony and our own witnesses' testimony, we got it out there that the claimant had only been a groundskeeper for 1 year, not 12 years. The claimant had worked for the company for about 12 years and had done another job with the company for those other years before he became a groundskeeper. But those jobs were different, and they had different, job duties and time spent on different activities, which obviously would be relevant to considering whether, the claimant's job duties led to him developing carpal tunnel. But most notably, we got the testimony out there that the claimant hadn't been a groundskeeper for 12 years, as the doctor and his doctor believed to be the case. Also, we got a lot of testimony that undermined the credibility of what the doctor believed the claimant did on a daily basis, where our witness, who was the claimant's supervisor, was able to say the claimant did not spend anywhere near this much time doing these things. So the judge established that case, which was not really surprising, because the judge was able to just say, well, there's medical, and you didn't produce an IME, so I'm going to find causal relationship. However, on appeal, the board reversed and disallowed the claim for bilateral carpal tunnel, because they looked at the doctor's opinion and said, well, for one thing, the claimant's only been a groundskeeper for 1 year, not 12 years. So that's pretty notable to a causal relationship opinion in a repetitive use claim. And on top of that, the claimant exaggerated his job duties, so that, really through no fault of the doctors, who did try to satisfy the Patalan precedent, the doctor submitted an incredible opinion on causal relationship. So our practice point here is just please, please, please look closely into any causal relationship opinion you get in an occupational disease claim before you automatically accept it. Because a lot of times the doctors won't even go into any detail as far as the job duties that supposedly cause the occupational disease. And then sometimes, as happened here, with a little bit further investigation, you can find that while the doctor tried to satisfy Patalan, the doctor failed because the claimant provided an inaccurate history of his job duties. So just keep an eye out for that. That's all for today. Please subscribe below if you want to see more videos like this. And if you're interested in joining our LOMAD VIP, which will give you access to all our content, including the newsletter, please feel free to reach out. Thank you.